Okay, our next speaker is the Honorable Dawn M. McIntosh, and Dawn has been on the bench as a circuit judge since January of 2017 after winning election. She Northwestern Law School, right? Went to Northwestern School of Law. Been an attorney since 1992. She was a prosecutor in both Multnomah County and Clatsop County. In fact, several of you probably got hollered at by her when she was the chief deputy. I wouldn't be surprised, because it kind of tends to go with the territory. She was in Multnomah County for almost 9 years, and here 5 or about 5. And she then went into private practice in Cannon Beach from 2004 until she took the bench in 2017. She had a very successful domestic relations practice and left us alone for some of the time. She prosecuted murder cases when she was in the DA's office. She currently handles delinquency court and family treatment court, I think. She did drug court before that, and I would call her an expert on search and seizure, so you better pay attention. And she can throw you in jail if you're not. So anyhow, other than that, Judge, please take over.
Thank you. As Mr. Grant indicated, I've got a little bit of background on both sides. And some of you I know from way back when I was the chief deputy here, and some of you I remember writing warrants with. We used to do a lot of that together in a lot of the investigations. Search warrants, I don't know that I'm an expert, but I do know I tend to be kind of tough on them. I know some people get set back a few times, and I'm going to keep this pretty basic, but I'll try to leave room for questions because I know there are some people who've had specific questions. So, see if this works. I'm not a PowerPoint expert. This is where the requirement for warrants comes from, the U.S. Constitution, 4th Amendment. Everybody should know that, but start off with that. And our own Oregon Constitution, Article 1, Section 9. That's the basic tenet for every search warrant that you ask for. It applies to every form of invasion, whether it's physical into somebody's house, electronic into their computers. Can you hear?
Oh, sorry, Judge.
Whether it's physical into somebody's house, electronic into their cell phones or computers, which is a huge area that's evolving right now in the law. Any kind of technological intrusion. There was a case a while back, I can't remember the name of it, but where the court held that touching someone's car after it pulled into the driveway to see whether the engine was warm was actually a search. So, and then there are a number, let's go back, of Oregon statutes in this section. And I'm not going to read them all to you, but that's where they are. If you want to know how to do a warrant, it's pretty basic stuff, and it tells you what you can do, how to do it, and all of that. And return to the warrant. I'm going to go over a couple of these because these are some things that I think are important. This is what you can look for. You can look for evidence of the commission of a criminal offense, contraband fruits of the crime, or property that has been used or possessed for the purposes of being used to commit or conceal the commission of offense. You don't get to look for anything else. That's what they say. That details what you're supposed to put in the warrant. It's very, very basic. The warrant has to describe with particularity, we're going to talk about this in a minute, the identity of the judge. So you've got to know which judge you're going to. My name has got to be on there, and the date and time. Name of the person to be searched, location, designation of the premises, things constituting the object of the search, and this is where we get into trouble sometimes. And that's the time frame you got to serve it in. If you don't serve the warrant in time, you've got to return it to the judge. So you don't get to hang on to it and do it later. Probable cause. You all had training in DPSST. You should all know what probable cause is. But in a search warrant, it's very specific. You need probable cause for 3 things. That a crime has been or is being committed, that evidence of that crime actually exists, and will be found in the place you want to search. Probable cause exists when facts set out in the affidavit would lead a reasonable person, and this is what we learn in law school. It's all about who's the reasonable person. You take a typical reasonable person, not a cop, not a judge, but a reasonable person, to believe that things you want to look for, evidence of a crime, will be found where you want to look. It's more likely than not, it's not beyond a reasonable doubt. It's more than a mere possibility, and frequently I see in search warrant affidavits there might be, or could be, or that people sometimes do this or that. It's got to be probably, and I probably have sent some of them back to you for that. When you're telling me I want to go look here for what I think is going to be here, it will probably be there. Otherwise, you don't have probable cause. If it might be there, it's not probable cause. And it must exist, the probable cause, at the time the order is entered. two areas that the Court of Appeals seems to get into a lot are the issues related to warrant, particularity and specificity. Particularity refers to the description of the items that you want to seize. So that phrase and any other evidence of the crime, we really like to avoid that. You need to give some particulars. So I want to look for methamphetamine. I want to look for heroin. I want to look for syringes. I want to look for scales. I want to look for, those types of things. If you don't know exactly what you're looking for, and there are some cases where you don't, you're going into a murder scene, you're going in on something where you know a crime has been committed there and you're looking for potential DNA evidence, describe it as specifically as you can. This is where we see the Court of Appeals and the Supreme Court coming back and kicking things out. And you're all familiar with Mansur 1 and Mansur 2. And even though the Supremes, we'll talk about that in a minute, but even though the Supreme Court kind of backed off on some of what the Court of Appeals said in Mansur, they actually reaffirmed some of what they said. So it got better with the Supreme Court, but there's still some real issues. And we'll talk about computers in a minute. The warrant has to describe, the warrant itself, not just the affidavit, with as much specificity as reasonably possible under the circumstances, what you believe you will find. What about training and experience? This is a fun one. It's important, but alone your training and experience is not enough to get a warrant. Just because you know that drug dealers frequently keep drugs in their house doesn't get you there. And there's some cases directly on point. You've got to tie your training and experience directly to the facts that you observed. So training and experience is not in and of itself probable cause, but it's the lens through which you look at facts differently than what an ordinary person might. So for example, you see a little white paper fold on the floor of somebody's car folded a certain way. Based on your training and experience, you have probable cause to believe that it contains some sort of a controlled substance. But you got to tell the court, you got to tell in your affidavit what that training and experience is. It's examined on a case-by-case basis by the courts, and it just really is very fact-specific. It's best used, the training and experience is best used to provide some sort of a criminal law nexus to the series of facts that you've got in front of you. So you've got these facts, and when you look at them through your training and experience, this is what they mean. And it's important because there are situations, again, that you will recognize because you've got training and experience that an ordinary citizen might not recognize. So, some suggestions for preparing the affidavit. You got to know the elements of the crime. So don't assume you know them. I mean, you've all been through DPSST, but every once in a while you're going to get a crime that you don't have all the elements of. Know the elements. Go back and read the statute before you write your warrant. A good source for the elements of the crime are the Uniform Criminal Jury Instructions. The DA's office has a copy. I think you can get them online, but it's what we tell jurors, and it's written in common sense, plain language for an ordinary person to understand. The elements of driving under the influence are, and that's what it'll say. 1, it happened on such and such a date in Clatsop County, state of Oregon. Somebody drove a motor vehicle on a public highway or premises open to the public well under the influence of intoxicants. And each of those elements, and they lay them out, 1, 2, 3, 4 in those instructions, you've got to have probable cause for every single one of those elements in your affidavit. Boilerplate language is okay for some things. All of you who write warrants really should start, if you haven't already, keeping your training and experience saved on your computer. And you just add to it every time you go to a training. You add to it and you add to it. But tailor it to your case. I don't need to hear about, all of you know about pedophiles if what you're writing is a drug warrant. You can don't be afraid to edit your training and experience to tailor it to the facts of your case. It helps, I think, when writing warrants, and this is the way I taught them when I used to teach classes on this to cops, is you have an outline. Start from an outline. Start with training and experience, a basic summary of what you're doing here. I'm writing this warrant to request to search for X because I have probable cause to believe this crime was committed and whatnot. And then go into your facts. Most of the time, facts, I think the warrants that seem to work best, the affidavits that seem to work best, they're chronologically done. That's usually the way to do it. Now, there are others, certain complex investigations that maybe you can't do it that way, but lay it out, again, in an outline form.
Excuse me, Judge. Skip over things. It takes sometimes a long time for you to get to the right point, and you don't need to take the judge through all those little rabbit holes that you went through to get to the point where you really found the evidence. You don't have to take the judge on the full gamut.
Everything doesn't have to go in the affidavit. There are things you want to be careful about leaving out, but everything doesn't have to go in the affidavit. The facts in your affidavit, and this is where I also see lots of problems, you've got to attribute them to your source. It is, I spoke with Deputy Scheimer, and he told me that he had interviewed Mrs. Smith, and Mrs. Smith told him. You got to tell me where they come from. Just because, conclusory statements like the investigation revealed, which I see a lot, or, those types of things, toss them out. Your conclusions come later. What we got to know is where the facts came from, because we have to sign off on this is credible information that supports a probable cause finding. Include information bearing on the credibility of your source. If you're relying on hearsay, which you can in an affidavit, because it usually are. You're talking to witnesses, this witness had told you X, Y, and Z. If there is information that makes that source that you have more credible, put it in there. If there's information that may affect their credibility negatively, put it in there. Because that's where you wind up in trouble in the courtroom when you left out of your affidavit that the person that told you this has 3 convictions for perjury. So you gotta let the judge know that stuff. You don't want to get a warrant that's not going to be upheld, because that'll be the one you find the dead body in the trunk on. Keep the language simple. It's a pet peeve of mine when you guys use military time. And anybody who's been in my court will know that, because when you say 0800, I say, what time was that? Keep it simple. Avoid police jargon. DUII is driving under the influence of intoxicants. You didn't exit your motor vehicle and go travel in a north direction. You got out of the car and turned left. Avoid conclusory statements. That's the one I said. We investigated and determined. Describe actual facts and attribute them to their source. Identify the other law enforcement officers whose information you're relying on by their full name and rank, at least the first time that you put them in the affidavit, because you have to assume that the person reading it doesn't know who these people are. So I spoke with, Sergeant Bruce Holt of the Seaside Police Department, who I know to be a peace officer and reliable. I mean, you say that, and then after that, you can just call him Sergeant Holt. I avoid repetitive statements. Say it once and move on. I don't need to hear the same thing 10 times. State your facts objectively. In the facts section of your affidavit, you're not arguing for probable cause. You are laying out a set of facts, and you want to state them as objectively as possible. In the conclusion, you can tell me why you believe you have probable cause. Don't forget to tie it together at the end and ask for what you want. Based on the foregoing, I am requesting a warrant to search Joe Smith's house for evidence of the crime of burglary, and I'm looking for X. And I believe probable cause, this affidavit supports probable cause. If you have what we used to call expertise warrants, and I know I've done a couple of them here, be sure and ask for help if you haven't done one. Talk to your DA, talk to your detectives who've done them before. We used to do a lot of what we call expertise warrants on pedophiles, because we all know from training and experience that pedophiles keep things forever and ever and ever. And I can count a number of cases where we went into houses and grabbed computers and grabbed photo albums back then and videotapes from people who were pedophiles, and they date back 20, 30 years. There's a lot of information about that and a lot of training and experience, and you can get warrants. And there's actually a fairly recent case, I think it was 2010, I guess that's not that recent, that supported that. But you gotta really have the training and experience piece on those types of cases. So if you're gonna do an expertise warrant, talk to one of your detectives who's done them, talk to your DA. One of my pet peeves when I was a DA, and I said to everybody back, one of the first questions I ask you when you come into my office to have me see a warrant is, has your DA reviewed it? Have you taken it to the DA's office? Because these guys keep up on the law. They know their stuff, and they need to...
Judge, can I, before
Sure.
you go on to the next, how much, if any, attention do you pay to the suspect's prior criminal history regarding the probable cause computation?
It depends. Prior criminal history, and there's some cases, prior criminal history of like drug abuse or drug dealing and possession of a controlled substance doesn't get you to probable cause to go look. You got to have more. So I do pay some attention, and it can be part of that, but not a ton. And I've seen it
tied into something.
there's got to be a reason for it. Yeah. And if you don't have the facts, and we all know people that are out there on the street that one would call walking probable cause, but the Court of Appeals and Supreme Court don't recognize that. So even though this is a guy you've arrested 10 times for drug dealing, you better have facts this time that support that. Toss the other stuff in, doesn't hurt, but I'm not going to issue a warrant just based on somebody's criminal history. So this is one of the areas that's really still evolving. Computers and cell phones. You've all heard about Mansour, and it was adjusted by the Supreme Court. They actually overturned the Court of Appeals, but they did so with some really interesting language. Computers and cell phones are different than most evidence. Most of the time, when you get word to seize a piece of evidence, the person who you're seizing from loses all their privacy interest in that piece of evidence when it comes to law enforcement. And so after that, they don't have any more privacy interests. There's nothing else to protect under the Constitution. Mansour, and one of the things the Supreme Court said is computers and cell phones are different because the digital information they contain, this is a quote from them, implicates constitutionally protected privacy interests that are equal to or surpass those of a home. And that's a home, according to the Oregon Supreme Court. That means they're treating computers and cell phones like you want to go into somebody's house, and it's because of the treasure trove of information. So what makes them so valuable to law enforcement also makes them something that the court is going to protect unless you have probable cause. The other thing is that because the manner in which you have to search a computer is always likely to uncover other stuff that is not related to your investigation, there's some real question about how they're going to treat things, and we'll talk about that in a minute. It's really unclear whether the plain view exception is going to apply. Plain view exception, you all know, is when you walk in doing a search warrant and you're not looking for drugs, but you see a big pile of heroin on the table. You're someplace you lawfully have a right to be, and it's in plain view. You can seize that. That's an exception to the warrant requirement. The problem with computers is this: when they go in and do these searches, if they have to take it all apart and look at all these other areas, it's not clear whether the court's going to support a sort of plain view. So you're in there looking for evidence of a burglary, and in going through these photos, you spot child pornography. The argument I would make is that's in plain view if you're where you were authorized to be. Mansour didn't address that because it didn't get argued, and they specifically said, we are not going to address whether the plain view exception applies to computers. But the thing you need to know is that the authorities are split. When you look at the federal courts of appeals and you look at the other states, there is a split down the middle on whether or not plain view applies to computer searches than cell phone searches. So the better choice is to look for as little as possible in Mansour, and I don't know how many of you know the facts of Mansour, but one of the things that I think that they really took out of that was they got the computer and they said this is how we're going to search and what we're going to look for, but then they kept looking, they looked for other things. So where they were going to look on this date because he said he'd been on the guy that killed a baby, said he had been on the computer that day checking about what to do about the baby. And when they get in there, they start searching terms like abuse and searching other terms that weren't related to what they got the warrant for, and they lost those. So and what they found was that for months and months and months, this guy had been researching how to stop a baby from crying. What am I going to do if I abuse my kid? I mean, stuff that was so clearly attributable to what he was doing, and they tossed all that out. And the way I read Mansour, and Ron could comment on it too, is that the big reason behind that was because they went looking in other places and specifically for other things that weren't tied to what the warrant was for. They might have been able to get a warrant for those other things if they'd written it correctly through training and experience. I think they could have. I think they could have gotten to all those other items if the warrant had been written that way, but it wasn't.
Bad facts make bad law.
And that's the case. And that's why you especially want to be careful with computers, because that's exactly it. Don't look for it unless it's authorized. If you've got a warrant to go look for drugs, don't start looking at videotapes. Those are the things you got. Because if you look for it and find it, and it's not authorized, then they're going to toss it out. Identify what you are looking for as specifically as possible. The category or categories of information, including the time period when it was created, accessed, or otherwise used. So you're not going to get a warrant to go wholesale surfing through somebody's computer when what you're looking for is a photograph that you believe was taken on such and such a date. Make it a temporal, and that's one of the things that Mansour, the appellate court said, and the Supreme said it too. So Really important to time limit what you're looking for if you can. Include information if you have it. Include information if you have it on how you plan to search the computer or the cell phone or whatever it is you're taking. And I know technology is changing on a daily basis, but, and you may not know it all. If you don't know, if you're going to send it to another agency, call them and ask them how they're going to search it. They've got information for their warrants. I know that our detective for the sheriff's office has a lot of information on the different types of searches that can be done and who's going to do what. Use your fellow law enforcement officers about that. Don't just grab the cell phone and say, we're going to search it. If you know how you're going to do it, using the Cellbrite technology or chip-off technology, or say, and I've seen this done, we're going to start with Cellbrite. If we can't get it through that, then we're going to do the next thing. Some of the other issues, any questions about computers or cell phones? Okay. Some of the other issues, staleness. This is something that comes up pretty frequently. It comes up a lot in drug investigations. And these are the 5 factors that the Court of Appeals says you got to look at on whether or not evidence is new enough to get a warrant. The time, obviously, and it's more important in certain types of cases than others. The perishability of the item. Drugs are perishable. Drugs are mobile. The next one, are they mobile evidence? Non-explicitly inculpatory character of the evidence. I don't really even know what that means, except it just isn't obviously criminal. And the propensity, the last one is propensity of an individual or class of offenders to maintain or retain possession of such evidence. That's where what you asked about, Ron, with the criminal history or experience dealing with this person. I found drugs in these places with him before. The notes down here, those are from 2 cases. There was a case fairly recently that said 96 hours was too much after having seen drugs at the residence to go in. This was marijuana, but they said it was too long. That was too much time. They also, there's a number of cases on the issue of drug deals at certain houses and trying to get into that house and go search that house where you know you've done your CRI into that house a couple of times. Well, if it's not the residence of the person that was selling the drugs, there's a case out there that says you got to tie it, you got to give me more. Even if they've conducted the drug deals at that house 3 times in a row, if that person doesn't live there, that's not enough. So that's from a case. And then this is sort of our final thing. If you remember nothing else of what I say today, number 1, do not call us until your affidavit and warrant are written and converted to PDF. You know, we all get up in the middle of the night to answer warrant calls, and there is nothing worse than having that 2:30 in the morning call from the officer to tell you that he's getting ready to write a warrant, and he'll be sending it, or she'll be sending it in another hour. Absolutely don't do it. It just makes us angry and grumpy. If you don't know how to convert a Word document to PDF, learn it before you apply for a warrant, because we sign them in PDF. You can't send them to me in Word. Make sure the date and time of the incident are included on the affidavit. And these all come from, this is a list that was put together by the 3 judges about the things that drive us the most nuts. Sign the affidavit before you email it to me. If you want a blood draw, for example, on a DUI, which are the ones we see most of the often in the middle of the night, don't list blood, breath, and urine. If you have probable cause for alcohol, if you have probable cause for alcohol, but not for anything else, don't ask to search for controlled substances. Don't ask to test for controlled substances. If you think you have probable cause for controlled substances, meaning probably, not maybe, probably, then give it to me and I'll give you the warrant. Oh, come on. If you are using a template, like everybody does on the DUIs, learn how to edit it. Scott McCracken has the key to open up that form so you can take things out that don't apply to your case. Give the judge a good phone number so she can call you or email you. The fact that you happen to be working a graveyard shift is not a good reason to call for an after-hours warrant on something that is not urgent. I once had a call in the middle of the night on a warrant on a case that they'd been working on for 6 months, and I think it was a fish and game case. And they just were coming over the next day and wanted to serve it the next day, so we get the call in the middle of the night. That is not an emergency that you call the judge for. If you're working a graveyard shift, get up in the morning and call me in the morning or stop by the office.
Contempt of court is a very broad power that judges have, so take it seriously.
Telephone warrants. The recording is the affidavit by law. If you don't have the recording, and we don't do many of these anymore. I've done one recently, and the reason I bring this up is I think the recording system didn't work, which means that case is going to get tossed the minute the defense attorney looks at it, because there is no record of the affidavit now. The recording by statute is the record of the affidavit. You have got to bring that to us, preferably the next day, and I have to listen to that recording and then sign it again and sign off that that's probable cause. So if you don't have the recording equipment, don't ask for a telephonic warrant. We do most of them by email now, but occasionally I think one of the officers caught me on the golf course and I didn't have my computer with me, so we did it as a telephonic. And we used to do a lot of those. But if you don't have the recording, you can count on the fact that your case is probably going to get tossed.
Do you care if we do telephonic versus the email?
No, we prefer the email. We really prefer the email. It's much easier to read and see whether or not there is probable cause. If there's good reason to do a telephone, if you don't have time to write an affidavit and it's a really good reason, then we'll do them. But it's more difficult to just listen, especially in the middle of the night. You know, I got to wake up, put my feet on the floor, and pull up the computer. But emailing it to us is much. It's much better, it's much cleaner. There's a guaranteed record because we've got it on our computer, you've got it on yours, and if something goes wrong with the recording equipment, and I got to tell you, after all the years I remember working in the DA's office up here and down there, cops and tape recorders just never seem to mix. And something always, it'll be that big case, and I remember a murder case with Joe Calistro where that big case where somehow the button didn't get punched or you didn't, you know, something happened and went wrong with the tape recorder. You're better off to email it if you're going to have to write it out anyway, so better off to email it. Any other questions about warrants, about anything that you need to know? Feel free to ask me pretty much anything. This is your opportunity. Go ahead.
So if we have a person who's been in a crash, in a DUI, suspected DUI crash, they're brought to the hospital.
Mm-hmm.
Let's say that we can't get an implied consent blood draw.
Mm-hmm.
Would you prefer if we do a warrant for their blood to be drawn by medics or a warrant to be taken from the blood that is drawn by the hospital?
That's a question for Mr. Brown because he's the one that's got to prove the case.
We usually want to get the hospital blood and we want to set a separate draw for ourselves.
That's the other thing that I have to, yeah.
Hospitals don't always have a chain of custody thing, which we typically have to have in a criminal case.
Yeah. And that's the other thing that you have to keep in mind about us. There's a real argument among members of the bench about how much we can actually do when you bring us a warrant. Now, those of you know, I will tell you that I think these need changes, but that's a fine line because I have to remain a neutral magistrate. So even though I want you to give me a warrant that I can sign, and I'm not going to sign something, I can't give you the kind of advice that Mr. Brown can give you. I can tell you why I'm not signing it. I can tell you what the issues are. But there are members of the judiciary that absolutely say they won't even tell the cops. So they just say, I'm not signing this and send it back. I don't think that does anybody any good. I take, the protection of the community part of my job really seriously. And so I think it's okay. But again, there's a split. There are some judges out there, and I've met several of them that say they don't give any kind of feedback on when an affidavit comes in. They just send it back if they're not going to. They just say no. But I won't do that. I generally will send it back. So, any other questions?
When are you going to run for Court of Appeals?
What's that?
When are you going to run for Court of
Yeah.
Appeals?
Oh, I don't know.
Do you see any time in the near future that they'll do away with blood draw warrants, reverse it, that they'll realize that it's a lot more intrusive doing a forced blood draw rather than taking somebody for a refusal?
Yeah, no, I don't think so. I don't see that as being the issue that the Court of Appeals is going to take up. Legislature maybe, I don't know, but I don't see that as the issue. The issue going forward, there's two big issues. The computers and cell phones are the number one issue that you're seeing all over the country. I mean, the Supreme Court, United States Supreme Court came down with a decision last year, Riley, that basically really, because they are such a treasure trove of private information. The most recent thing I saw, and I've only seen one of them, and it's going on back east a lot, and some of you may have gotten some training on it, are these warrants for GPS data from the cell phone companies, basically where you don't have a suspect and a crime was committed here, and you want to get the data from the cell companies to see whose cell phones were in the vicinity at the time this crime was committed. And that's a really touchy issue. The first one came to me a couple weeks ago, and I ended up signing it, but boy, it was.
Put a lot in it.
And the reason it's such a big deal is this: the likelihood of you getting information on people who didn't commit the crime, people who are in the, like, say you want the there's a Labor Temple robbery, and you know people carry cell phones. Almost everybody and their dog has a cell phone in their pocket, no matter where they're going. And wherever you're going, even when you're not talking on your cell phone, Google and the cell phone companies, they're tracking that phone. I mean, they can, even if you haven't talked on it, if it's just in your pocket, they can track where your phone was, and they keep that data. And so some real clever law enforcement back, I think it's Michigan, where they've been a lot of them right now, have come to the conclusion I can get a warrant to get this data, and once I get this data, then I can look at whose numbers these are. I can do more investigation. Then maybe I can get a warrant to go get them. So it's a pretty big intrusion in some respects, although you're not really going for confidential data. But basically, you can track everybody everywhere that carries a cell phone. And since, even the Supreme Court said 98% of the people in the country, even people who live on the streets, are carrying their cell phone in their pocket, their smartphone. And so there is no appellate case law anywhere on this stuff yet. It is so new. And so it's an area that I think you really got to be careful of. And because basically what Ron said, bad facts make bad law. I think you want to be selective in what you use them in. You want to tailor it as narrowly as possible. The one I did was actually it was a fishing game, and it was a boat. It was some crab pots out in the middle of the ocean. So the likelihood of this search catching everybody else's cell phones was slim to none. It was a 1 mile square area out in the middle of the ocean. So they got enough stuff in there that I felt comfortable with that. But it's a really interesting area. And again, bad facts make bad law, and it is such a powerful investigative tool if you think about it, to be able to go in and say, there was a murder here, this is where we found the dead body, I just want to get cell phone data, and maybe I can tie a suspect to it if you don't have any. I mean, it's just, it's the possibilities are endless of that. But you get somebody pushing that too far, and you run the risk of losing the ability to do it. I think that's kind of what happened, on a total aside, in the area with our CARES tapes. We used to be able, Ron has a much harder job than I used to have. When I used to do child sex cases, we could get those videotapes in under the medical exception in every case, and we could use a diagnosis of sexual abuse or physical abuse even without physical findings. In recent years, the courts changed that completely, and they did it because I think, this is my opinion, that too many of the centers that were doing them pushed too far away from that neutral fact-finding medical exam to advocacy centers where it was clearly about assisting prosecution and cops. And the Court of Appeals, that's what they said. They said these are not just medical appointments, these are arms of law enforcement. And that had been argued for 20 years. And they hadn't bought it, but the further, and it wasn't our center here, but the further some of these centers pushed towards, being more advocacy oriented, doing grand juries at the center because it was more kid comfortable, having that kind of stuff, that's where the Court of Appeals slapped it all down, and we lost the ability to do it the way you used to be able to do it, which really causes problems in a lot of cases. So I think it's really, really important that you tread carefully on these areas where there is not a lot of legal authority. We don't have any case law in Oregon on that issue of grabbing that data. But Mansur in the Supremes, when you read through it and you read between the lines, they talk about, we get that intrusions into these areas in people's lives are so significant, we're going to treat them differently than we treat other evidence. And so that's pretty good. The issue of the plain view exception, that's one I'll be real interested to see what they do with that. Because again, I think the argument is if you're in there searching in the computer, searching in the place where you said you were going to look, so this time period, and you happen on something else that you're legally entitled to be there, I think it makes sense, plain view wise, that if you're where you're legally entitled to be. But if you're out there and in there looking for something else, searching other terms that are related not to what you were looking for, but to something else, then I think you're going to wind up in trouble, and you're going to end up losing lots of good evidence, because frankly, lots of good evidence comes from the computers and cell phones. So.
And we need to create our good factual case in order to be able to get a good ruling from the courts.
Yeah. So if you get one of those, again, I'll just encourage you. Scott's here, Don's here, Ron's here. Use your district attorneys. They read the law. They see the appellate cases that come down. This is an area that is constantly evolving. You can learn one thing today, and tomorrow I'll have to tell you something. You'll come into my office and say, oh, wait, I was wrong. They changed their mind. They're doing something different. So make sure, if any chance you've got, have your DA review it before you go in. And if you've got a unique scenario, one of these GPS position kind of warrants, talk to them beforehand. They may even want to talk to the AG's office because, again, you really want to be careful about not being that county or that cop that screwed up this investigative technique for everybody. So, any other questions? Go ahead.
Regular DUI, but it's total refusal.
Mhm.
Won't do anything. So when we're going for a warrant, personally, for time's sake, it would be sometimes much easier, especially if it's a busy holiday or medics are super busy. If we could just do a warrant for breath, it would be a big time saver, not having to wait for medics to do it. So I see that on your board.
Yeah.
You just want this, please just ask for this.
Yeah.
If we have explanatory verbiage to say, for time's sake,
Hmm?
we'd like to get breath.
You could do a warrant for breath. I mean, yeah. It doesn't mean they're going to comply. We can't grab their head and shove it into the intoxilizer.
Then the problem is, if I just ask for blood,
Mhm.
right now we've got an issue where, okay, if this person starts sweating, cry,
Mhm.
I'm not going to strap them down and take the blood.
Yeah.
So then my whole warrant process gets thrown out. So I think that's
See-
why you're seeing asking for breath for this. Is that
You can ask for breath and blood if you want both of them. What I see more of is you want breath, blood, and urine. When you don't really want urine, you don't have probable cause for controlled substances, you have probable cause for alcohol. So toss that out. The other thing you should know is this. I won't touch your affidavit in terms of making changes to your affidavit. That's your document. That's your sworn testimony under oath. But the warrant is mine. So once you've done the warrant, and some of you have seen this, if you send it to me and you say, hey, I want to search for this, this, and this, and I'll say, now you have probable cause for this, this, and this, I'm not giving you a warrant for these other things. And I'll cross those out because that's my document. My signature goes on that. So it's easier if you just put in there what you got probable cause for, but sometimes other stuff gets left in. And sometimes I'll ask, what's your probable cause for and I've asked a number of you when I get these DUI warrants that say you want breath, blood, or urine, and you want to search for alcohol or evidence of controlled substances. I say, okay, what's your PC for controlled substance? Dead silence on the other side of the line usually. So if you've got it, if the guy said I was smoking weed, or you've got drugs in the car, or you've got some sort of a DRE exam, if you've got something that indicates that you've got drugs in the system, then yeah, and it's probable cause. Go ahead.
What about the fact that alcohol is a CNS suppressant, and so you're going to see potential effects of the same thing you'll see from the Xanax or any other depressant? If you just articulate that
I don't think that's enough. I don't think that's enough.
well, a nice diagnosis is indicative of a CNS suppressant. Same thing we would put with alcohol.
I don't think you get to the probably level just with an HDN on controlled substances. Tell me why you think, and you've got to really believe it. You got to really believe that you are probably going to find evidence of a specific controlled substance in this person's system. So you got to have something else. Especially if what you're telling me is you've pulled the guy over, he's stumbling, he's breathing alcohol, he says, I had 3 beers, you get him down to the station, he says, I'm not blowing, then you get your warrant. There's no probable cause in that fact scenario for controlled substances. And just because some controlled substances might affect people similarly to alcohol doesn't get you there.
The officer's like, I don't smell any alcohol, I'm seeing all the indicators of a depressant. Then add
Absolutely. Yeah, say what you're looking for. This is, yeah, and the DRE exam is a good one to look at, because that's what you run them through. You run them through the DRE, they say no to the urine, and then you have to get a warrant. But in that case, do you want a breath test? Yeah, you do, because you want to be able to demonstrate that there isn't any alcohol. But say what you want and what you've got probable cause for, and don't be surprised if we ask, what's your probable cause for this? And I've asked people that before. Yeah.
So, Jonathan, low, they said they had 3 beers.
Mhm.
You're seeing, so now they're only an 0.3, and you're seeing this incredible. Then we would have to do an amendment to that, call you back, and then ask for, if there's both, there's a possibility of both.
I think so. I think you'd have to do another one, unless you've got probable cause before you do the breath. I mean, you think, unless you have signs and symptoms of under the influence of a controlled substance, and facts that support that probably there is a controlled substance on board. The person tells you, I took 2 Xanax before I, had my 3 beers. That gets you there. I took my Adderall prescription and then went out and had whatever. That gets you there to probably, because you've got, the behaviors that are consistent with what they say they took or whatever. And that's the thing to just remember. It's got to be probably. It's not I might find, it's not I could find, it's not perhaps there will be. It's not a fishing expedition. You got to be able to say, I believe that I will probably find X in this person's blood. Any other questions? Okay.
Thank you very much, Judge.
Thank you.
Pleasure having you over.
Thank you.